So, of course, since this is going to be the pivot of our discussion, I'd like to begin by starting down on what the background was for the court judgment, and for that, I'd like to hand it over to Jairaj.
Right. I'll begin with the first question in that case. Beginning with the background of the judgment, there isn't much data or know how in the public domain about public sector undertaking these PSU arbitrations. Besides the facts of this particular case, could you tell us a bit more about the broader context in which this issue actually arose?
See, in India, before the 246 Law Commission report came, unilateral appointments being made, appointments being chosen from, say, a panel just curated by a party, that is the PSUs more so in these matters, was an accepted norm. There was found nothing wrong with it. There was nothing violative of the Arbitration Act or the spirit behind it if this was done. And you must keep one thing in mind, that in a country like India, PSUs are hugely involved and deeply involved in large parts of commercial activity in this country. And very often you have largesses being distributed, of course, as per norms and as per provisions and judgments as laid down. But there's a deep state and PSU involvement in commercial activity, and very often players, even if they want to, are engaged with PSUs. And I'm saying this with a reason, because that is where the importance of the fairness of contracts with PSUs and the state come in. And that is which I link it to the later part where the court felt the necessity to get into public law issues, because that's a question of debated on public law issues. I'll come to that. But you must understand the deep, pervasive state control or involvement in commercial activities in this country. Now, unilateral appointments or a panel curated was supposed to be the norm till the Law Commission came up with its report and said, look, impartiality, transparency, fairness are the bedrocks of arbitration in which people have faith. And not just in India, but cutting across jurisdictions in the world. These are the bedrocks, the fundamentals of an impartial arbitration anywhere in the world. And if there is no impartiality, there is no sanctity to an arbitration. Now, it was in these backgrounds that amendments were suggested to the Arbitration Act to say that, there are certain arbitrators whose role, say as an employee initially, etc., would raise justifiable grounds of lack of impartiality, and that was what 12.3 embodied. Then there were cases under which you were, say, covered by the 7th schedule, and in such a case, if you were hit by it, you cannot be an arbitrator at all. Now, those got incorporated, and the legislature actually accepted the 246 Law Commission report and brought about all the salient changes and recommendations made into the statute by virtue of it. Now, those are the judgments which ultimately came, those provisions of which ultimately came to be interpreted in TRF and Perkins to say, because as I said earlier, there was that whole view from Raja and other judgments to say that if a panel is curated or a unilateral appointment takes place, what's wrong with it? There's nothing wrong with it. After all, there's party autonomy. There's party autonomy requires it can be done. Parties have agreed to it. So what's wrong with it? Now, these judgments came and said that, look, by virtue of the amendments made to the statute and by virtue of the principle of impartiality, if a person is not eligible to be an arbitrator because he's an interested party, how can he control the appointment of an arbitral tribunal? Because then, as the words used were, you are determining and charting exclusively the course of an arbitration proceeding. Now, that can't be done. Now, so that was the line which, according to me, was the welcome modern way of thinking, step in the right direction, making arbitration, emphasizing the importance of fairness in arbitrations, transparency in arbitration, and the correct line taken. Now, then there was the core line of judgments which came and said that a panel out of which say, I think it was the GM Railways, if I'm not mistaken, in that case,
Right.
sent to a 4-panel arbitration panel, and you select 2 out of them, and then the GM selects 1 out of them. And other than that, the GM can select a person from within or outside the arbitral tribunal, the other 2. Now, this was held to be, surprisingly, a fair method of appointment of arbitrators. Now, obviously, parties like us who appeared and many other affected parties had serious issues on this, and the court also felt that these raised serious issues, and ultimately it came to be referred to a constitution bench. So the issue which we also argued there was that, look, merely because you give me 4 names, and out of those 4 names I select 2 and then you select 1, where is the freedom in this? Why should you alone have the say in curating a panel? Why can't I also have an equal say in that we choose our respective arbitrators and they appoint a third arbitrator? That's the principle of counterbalancing, which TRF and Perkins recognize. So the journey to answer your question on background is that unilateral arbitrations, curated panels were the accepted norm till the 246 Law Commission report came, got incorporated into the statute. TRF and Perkins recognized the principle of fairness and transparency, and that impartiality is the bedrock of independent arbitrations. And then the line which was taken was by Core, which Core thought was a good answer and a justifiable defense of impartiality, was ultimately held to be wrong law and overturned. That's the background to what happened in the current Constitution Bench judgment that we are talking about. And Rohan can correct and add to it if required.
No, sir. That's as complete an answer as possible. So.
Yeah. Now, yes. Go on. What's your next?
Right. That leads quite excellently to my next question. In your arguments, you pressed Lombardy engineering, according to which an arbitration clause was held unconstitutional since it imposed a demanding pre-deposit condition.
Right.
Did you also press or foresee that the court would take the line which the majority eventually took, to read public law principles in Section 12, Clause 5 and Section 18 in determining arbitral impartiality?
You see, foresee I never do, because that's one thing I have learned in this profession, that you don't know what will ultimately be the outcome. And I'm very often very wrong with my guesses. So foresee not, but I definitely pressed the public law principles, because I'll tell you why. These are not just simple public law principles being pressed into service and purely private contractual disputes. That's a wrong understanding. You must understand, in matters like these, the Constitution Bench emphasized on a very important aspect, which must be something which you must analyze as students. They said, what is an arbitral tribunal? An arbitral tribunal is, at the end of the day, performing quasi-judicial functions, where you are deciding lists between parties, rights between parties, and you are really a fora created as a substitute to the courts and the legal system as it exists with a hierarchy of courts. Now, if you are deciding quasi-judicial decisions, etc., being made by it, and you're really a substitute for courts, in that sense, deciding lists between the parties, in my humble submission, public law principles must apply. Secondly, as in Lombardy, the court ultimately applied the principles of Kelsen, the Grundnorm, Constitution being the Grundnorm, and everything follows from that. At the end of the day, there can be no law in this country which is contrary to the Constitution. That's the most obvious thing to state. Every law has to be in conformity with the Constitution. So should the Arbitration Act be in conformity with the Constitution. Section 18 of the Arbitration Act, in any case, imbibes the principle of equality as laid down in Article 14. It's already there. But the reason the court emphasized was that you can't have unconscionable contracts under the Arbitration Act or any other law which violate the spirit of the Constitution, which being what? Arbitrariness. Equality is the antithesis of arbitrariness, as the Supreme Court and Justice Bhagwati held from Maneka Gandhi downwards. Now, if those are the principles pervading through the entire statutory scheme, and all laws, directions given in this country, I think the court was absolutely right in importing public law principles and saying that there has to be fairness, there has to be equality, there has to be transparency. And as I said, keep these principles in mind, keeping in mind that we are dealing with a case of not just any statute, we are dealing with quasi-judicial functions being performed. And quasi-judicial functions very often being performed by a public sector undertaking, which very often has large government control in it. And as you all would remember and would have read, that right from Dayaram Shetty downwards, the Supreme Court has held that even in private contracts, the states stand on a much higher footing than a private individual. The degree of fairness which is expected of the state is of a much higher degree than of a private individual, even in purely contractual matters. Because those arguments have been made, these are purely contractual matters. Why should constitutional principles be imported into them? And the court said no. Even in contractual matters, if the state is involved, the tests of arbitrariness, equality, fairness will all have to be seen there. So as I said, look at it at totality. Never pick up a principle in isolation and said, oh, in this matter, the court has imported public law principles. Why is it imported public law principles? Because you're dealing with a system of judicial decision making, which is created outside of the legal system. Outside of the legal system, meaning, of course, it's part of the overall laws of the country, but it's not in the hierarchy of the courts which is there. Now you will have to apply public law principles there when the arbitrator conducts himself as to bias, as to impartiality. There could be a debate on it, as there is a line which some judges, even in the Constitution bench, has said that principles of Contract Act and what is contained in the Arbitration Act are enough for that. And you did not need to import the public law principle. So there's that view that Section 23, 28 of the Contract Act were good enough. Section 18, read with 23.5 and 23.3 are good enough, read with the 5th and the 7th schedule, and you don't need to import. Could be. That could be a view. To my mind, importing the public law principles were perfectly in sync with the nature of functions that an arbitral tribunal performs under the Arbitration Act.
Thank you for that. So just to take off on exactly what you said was my next question. So, like you rightly pointed out, the court says that since arbitrators exercise quasi-judicial functions, they must be tested on the anvil of public law principles and doctrines such as that of bias. The first question that comes to my mind is, would this, on the applicability of this ratio, would this effectively mean that all arbitral tribunals, regardless of whether or not they were PSU appointed or exclusively by private parties, would be subjected to this touchstone? It seems to flow naturally from the premise that all arbitral tribunals exercise quasi-judicial functions. And even Justice Narasimha seemed to take a similar line in his judgment.
See, let me just emphasize for you a few principles, and then I'll tie it into your question and answers. What the 246 Law Commission report, headed by Justice A.P. Shah, one of our finest judges that this country has had to say. Some of the salient features of the 246 Law Commission report was neutrality of arbitrators with respect to their independence and impartiality was critical to the entire arbitral process itself. This is what the 246 Law Commission report said. And they said the test is not actual bias. The test is likelihood. And they noticed what were the problems in the unamended act and what needed to be done after that. And party autonomy was no answer to this. Now, having said that, in the given situation, the moment you perform quasi-judicial functions, you are deciding a list and rights of citizens of this country. How can it be said that you will not be? You ought to be governed by the constitutional principles of fairness and equality and impartiality. Because that will be the bedrock of decision making, of a fair decision making process in which the people will have faith, in which the courts will have faith. Look at the dangers of it, that if you have arbitrators in whom on the face of it, people have doubts about their impartiality, deciding lists between parties. and deciding lists between parties, especially where the state and the public sector undertakings are so powerful in these matters, where large largesses are being distributed by them, where they have deep involvement in economic activities, where will the impartiality come from? And as I said, it's not about actual bias. It's about the test of a reasonable man familiar with the facts of the case, what his impressions will be in a matter like this. So applying of these principles to the arbitral tribunals is something which is a natural corollary which must flow.
And just to add to Mr. Kaul's points, see, Justice Chandrachud quite interestingly in his conclusion said that Article 14 invalidity is for public-private contracts. He's not taken Article 14 invalidity to purely private disputes which you're talking about. He's interpreted the fact that for purely private disputes, it falls foul of principles of natural justice, which is also naturally a public law or an administrative law concept. The fact that Section 18, Section 12, Section 34 to that extent also have a public policy element to them, that you can question an award later on if it's against principles of natural justice, if it's against fundamental policy of law. So there's a measure or degree of control which courts in any case exercise on the anvil of public policy. But having said that, he didn't go so far as to say that, the standard of manifest arbitrariness or the tests under Article 14 would ipso facto apply even to private contracts. So that delicate balance is maintained.
Just to add to, Rohan has absolutely rightly explained that. And even in purely private contracts, the principles of 28 of the Contract Act would still apply. And 23 also incorporates the principle of public policy in it, which is of public policy of India. They're all incorporated therein. But when it comes to the arbitral tribunal, it's no longer about private contracts. It's about a body created which, in place of a civil court, is deciding lists between parties. It's performing quasi-judicial functions. How can it be said that the principles of public law, of constitutional principles of equality, fairness, transparency will not apply to it? It has to apply to it.
Noted. Thank you so much. That answers our question well. And just coming to the next point on, since you explained quite clearly what the implications of the judgment would be if it weren't held so, the unfairness that would be caused to parties on the grounds of party autonomy, what do you see the implications of this judgment as being? And this is a two-part question. First, on how private parties and arbitrations conduct themselves, or whether they would even proceed for arbitrations, or even PSUs, because it's now been suggested that after this judgment that PSUs would be more inclined towards institutional arbitrations. So how do you see the arbitration landscape changing after this judgment?
Their going for institutional arbitration is not worrying anyone. Institutional arbitrations is something would be an ideal situation where everyone goes for an institutional arbitration. There's nothing wrong with it at all. But if the argument is made that they will be reluctant to go in for arbitration, would instead go to the civil courts, if that is the argument, then so be it. The answer can't be because a PSU is upset with a Constitution Bench judgment, or they don't get to choose their arbitrators of their choice and thus they won't go in for arbitration, then so be it. Let them go to the courts. But that can't be a ground to permit them. They can't have an approach of it's my way or the highway and I'll appoint arbitrators who are my trusted people and they will decide the matters, or I'll be the only person who will have a say in appointment of arbitrators. Institutional arbitrations are welcome. There is nothing worrying about them at all. But if the PSUs, or the argument is going to be that this will make the PSUs reluctant because it won't have their choice of chosen arbitrators now, then so be it. I think then we'd much rather go to the civil courts and get that matter decided. It's a greater damage done to a list being decided between the parties where everything is handpicked and cherry-picked by one side and the other side has no say, or has a say which is a facade of a say, but actually there is no say.
Noted. Thank you so much, sir. Just to slightly pivot away from the judgment now, since we are on the subject of Section 11 applications in the Arbitration Act, it's been a continuing concern in the arbitration landscape that the scope for challenges in Section 11 compound increasingly the court's backlog with these applications. Do you believe that legislative reforms, such as those suggested in the TK Viswanathan Committee or the new draft bill, are sufficient or helpful? Or do you see more broader structural changes in arbitration related litigation as being more impactful?
Look, and I think now the answer I'm going to give you is going to get me into trouble. One is, at times legislative changes have been very welcome and very good, like the amendments brought about to the 246th Law Commission report. Now, those were categorical good changes in the right direction. But sometimes, and I say this with some concern as I've observed over the years, our legislative departments in the law ministry at times do not come up with the best drafts which are needed. I think we need far greater expertise in the legislative departments in India to come up with, because you at times create confusion, you create scope for dispute and you show lack of clarity where there should have been no scope for dispute and much greater clarity when you draft proposed legislations. So if there was to be a clear-headed, good amendment in the right direction, incorporating and addressing the problems which we are facing, addressing international concerns and practices, it's a welcome step. It's always a welcome step, and ultimately Parliament is the place where laws are enacted, and you have some of my finest minds sitting there applying their minds, so that would be a welcome step. But equally, I feel in India, a sizable blame on what happened with arbitrations and arbitration laws lies with the courts as well. I think the courts have swung in various directions while interpreting, adding to the problems very often than solving problems. If you recollect, there was a whole period which went by on whether Section 11 is an administrative function or a judicial function. Now, that was something which should have been avoided from the first date. And that led to how much litigation? Till ultimately it was concluded that it's a judicial function which is performed. Similarly, with the scope of interference, we were absolutely on the right lines on scope of interference that once an arbitral tribunal has applied its mind. Section 34 is not a court of appeal. Section 37 is even more restricted than 34. And yet the court started importing principles of Wednesbury unreasonableness, etc. into it. Till Justice Nariman rightly put a quietus to all this by saying that this is the scope and the width of interference under Section 11. Beyond that, leave it to the arbitral tribunal, whose width and scope of interference is wide, and let them decide. So to answer your question, coming back to Section 11, to some extent in some provisions, not in Section 11, I think the way the laws were drafted were a problem, although I feel the way the 1986 Act stood was a landmark statute in the right direction, imbibing and incorporating the UNCITRAL principles. Issues which arose with regard to impartiality and transparency and fairness got addressed by the 246 Law Commission report, and the Parliament rightly amended and brought in the right provisions. But I feel the courts also must sit back and reflect on the course on their interpretation of the statute, because very often a large part of this confusion has been created by conflicting views, with views which are actually completely contrary to the spirit of the statute, and ultimately then they got corrected by larger benches or benches of co-equal strength. So these are problems we have faced in this country with regard to arbitration laws.
And just to add with Section 11, you've had some recent judgments of Justice Pardiwala, State Bank of India, etc., which restate the same principle. As Mr. Kaul was saying, it's not like these principles have been lost on anyone. It's just that there's so many discordant notes struck along the way that he has to again say that unless it is dead wood, the arbitration agreement has to be followed. Under Section 11, you cannot go into principles such as whether limitation period has been complied with. Please adhere to competence. So with Section 11, there is an end point to which the legislature can impact the course of judicial proceedings. And after which there has to be some sort of a principle or a line drawn that, yes, I will follow this deadwood principle and I will not interfere unless there is a complete or patent absence of an arbitration agreement in the clause itself. And if you see the partly concurring, partly dissenting view in this judgment also, with utmost respect, if that judgment is followed, that at 11th stage you please pick and see which arbitration clause actually impacts independence and impartiality, and not every unilateral appointment is wrong. If that was the case, then every section 11 court now will have to see that is the clause as bad as core, which had 4 people, or is it akin to West Alpine, which had 33 people? And then that becomes another scope for judicial interference, and instead of reducing it, it compounds it. So it is opinions such as these which actually tend to compound the confusion with how section 11 is to be interpreted.
You see, very often today, when you have headlines in bar and bench and live law of a principle of law, it's actually a principle of law they're just reiterating, as Rohan said. And you're quite amused when you read again that bail and not jail is the norm. Now, it's being reiterated because there have been discordant notes struck. But it's reiterated because that's been the principle from times immemorial. And yet you have discordant notes in various aspects of law struck. And then when even the most basic principle is reiterated, it becomes headlines because we've almost forgotten what the basic principles were, since there have been so many discordant notes on various aspects struck. And that's where the courts also have to do some amount of introspection.
Good. Thank you so much, Mr. Kaul, Mr. Talwar. I think these opinions will resonate with the legal community, students, lawyers, and advocates alike. I now want to pivot the conversation to a slightly more personal note, especially for students and aspiring advocates to be in the positions that you are in. And for that, I'd like to hand it over to Uday.
Yeah, hi. Am I audible?
Yeah.
So, again, this is on a very lighter note. So, as a student, I can say that there are some career confusions in life. Students often struggle with what kind of paths they should take in their careers, especially in arbitration. Do you have any such advice for such students to hone in onto their calling?
Look, you should be asking these questions from Rohan. I'm a relic of the past. But nonetheless, let me share what do I say? Answers to these are easier said than done. Everyone has to find their calling. Please do not ever pursue a career or a field which you have no interest in. If you don't feel the enthusiasm in the morning when you get up to go to work, there are days we are all tired. We all crib on a regular basis. My wife tells me you crib so often. But that aside, there must be some interest. There must be enthusiasm to go to work. Your initial years, according to me, should never be restricted to domain expertise. In your first 7 to 10 years, to my mind, every young lawyer should get as varied amount of exposure that it should. Secondly, remember, if you want to be a litigator, your place is not sitting in an office 4 days a week and coming to court one day. Your job is to be in court day after day for the first 8 days. On that particular day, your boss may have a matter, may not have a matter, go and sit in court. And I don't want to sound preachy to you, but I can only share with you the principles that I follow. I think even observing counsels in court, listening to them, how they tackle, which are the cases unfolding, how does a judge react to them, are so important. But in your initial years, please do a varied section of work. Then decide where does your calling lie. Do you want to be a domain expertise person? Do you want to do a cross-section of work? Do you want to be a litigator, or do you want to be a non-litigator? According to me, it's better to try the litigator route first. And if that's just not your calling, you can go into non-litigation. Because to me, the real fun of the profession, the challenge of the profession, is in litigation. Not to say they're on the non-litigation side, they're not doing great work. They're doing great work. And a lot of it is an answer to the changing times and the economic needs and demands of the times. But if you want to be a litigator, come and test the waters in your initial years. See, I think the reverse is a bit more difficult, that you spend the first 5 years doing non-litigation, and then you decide to come into litigation. I think it's better to come into litigation, see if it's at your calling, which are the fields which interest you, and then go forward with it.
Yeah, I mean, I fully agree. See, the difference is that Mr. Kaul may say he's a relic, but he's a proved relic in that sense. So his advice is time tested. No, but on a serious note, in fact, just before this conversation started, Prem was asking me how did I end up where I did. And I said ultimately the only sort of advice which people like Mr. Kaul and I was interning with Mr. Dhyan Krishna at some time gave me is that do general work. Just do everything you can and go to a place which has volumes. So that's the same thing I said to Prem before the call also, that I don't think there's any good answer, but if there is one, it'll be to start with a broad base and go somewhere where every corner of the office has a file which you can just lap up and work on. And apart from that, I guess then ultimately it's your calling.
And your desire, very often, as I said, that ultimately it's your desire to learn which has to be there. There are cases where people have the desire, they don't get the opportunities. But I can equally tell you cases where people have the opportunities and don't have the desire or the discipline to seize the opportunity. Ultimately, that desire for knowledge, that quest for knowledge has to come from you. I very often insist on my people who join my chamber in the initial period. Everyone has his own system of working. I feel even if a person is not working on a brief, he must sit in a conference which he's not involved with. At least the interaction which takes place between the team which is doing it and me and the solicitors is a source of learning for the person concerned. Now, certain things have to come from within. If the person shows no interest, you can do nothing about it. And I'll tell you one more thing. It's a very wrong impression that we are a first generation lawyer. Will we make it? You will, of course, if you have it in you and you show the discipline and diligence, you will make it. Let me tell you, a lawyer who's not a first generation lawyer has certain initial advantages, I don't deny, in terms of placement in a chamber, an office, a place to stay. Those are advantages. But beyond a point, in my experience, and Rohan is a first generation lawyer, is a good example of someone doing so well in his own rights, that if you have it in you, you show the diligence, there is a place under the sun for you. I have seen second generation lawyers who were rather entitled, never worked hard as they ought to have, got things very easy in the initial years. Ultimately, they were nowhere. And the lawyers who came as first generation lawyers showed the diligence, the desire to work, going far ahead. So the initial road may be tougher. There may be days where you feel, where will I go? My parents are not from the profession. But believe you me, 9 out of 10, what I have seen is, if you imbibe the right qualities of discipline, diligence, and interest. If you're not interested in the subject, that's another issue. Then you shouldn't be here. But if you're interested in the subject, there is a place for you under the sun, definitely. Play clean, play straight, and I feel there's nothing which can stop you.
Yeah, I think that resonates with all of us here who are first generation lawyers, hoping that we can make our mark some way in the way that you have.
Of course you will. Of course you will.
Thank you so much, sir. Just on that note, now since we're in law school and since we're trying to find our way, and you recommended that you should try everything out, do you think at least as a student, there are certain qualities peculiar to an advocate or a litigator that a student can focus on developing?
Definitely. You have to learn to be articulate. You have to learn to be not muddled in a scrambled egg in your head. You have to have clarity of thinking in the way you present a case. Hone these skills, learn these skills. Also learn that in a country like India, a judge has read 50 to 70 files. The Supreme Court on a Monday and a Friday is like a T10. The High Court, you will still get a bit more of a hearing, but even that will be limited. Now, if you can't formulate a proposition or a point, it's all over. So, and the court and the judge justifiably also loses interest because he has so many matters to do. He can't keep listening to just one matter. And very often, believe you me, I have seen it in some very successful lawyers also. They know the entire brief inside out, but have no clarity of thinking and have no clarity in their presentation. So being articulate, not muddled, note your points, which are the points, the ones which you're going to address on, really, really helps. Plus, just because you see some counsels shouting around or being over aggressive, don't treat it as a great skill of advocacy. Believe you me, it's actually a failing in our system that some people get away with it. In no jurisdiction in the world will you be allowed to shout at others, interrupt others, and make a point. In fact, according to me, any counsel who presents his case with a great measure of, there's a certain way to do it, with a certain dignity, with a certain way of addressing the court, of a certain respect you show to the other side, is far better received by the court than a counsel who comes up and starts shouting. And especially if you're a young counsel. Look at the impression. A judge is hearing you and you're this young boy who comes and thinks, wow, this is the way to argue. Let me get really aggressive today. And outside the other side, be aggressive to the judge doesn't go down well. It's not a good skill set at all to possess. And I'm saying this because you guys, and we are to be blamed for it, because you guys see us performing in court and think, wow, this is the way to go about it. That's not the way to go about it.
Just to add, I mean, in my very, very limited experience, also just read, even if it's random. And we all, I mean, in our generation, and I'll count myself with you guys, have the benefit of a lot of online material. It's not just judgments, it's not just papers. So you never know what helps you. And you never know, like, don't underrate that power of spontaneity. That if you're actually arguing a case, you sometimes will recollect something which a judge has asked you from something extremely horizontally different from what you're doing. And so, yeah, I mean, just invite reading, and Mr. Kaul has said all the right things, formulating points.
And you know, as Rohan said, just to add to him, certain things you learn as you go along. Skill sets you pick up as you go along. There's no textbook that you come with when you come to court. Thinking on your feet. There's a reason when they say so. In a system like ours, there are questions which will come, tangential questions which will come from a bench. You will develop the ability. Naturally, on the first day, you may be a bit flustered, but as you go along, you develop the ability to deal with them. So, and have your own style. You never copy anyone, because you are you. As your generation says, you do you. So you do your bit and you move on. But never copy a style, learn from a style. If a person is arguing in a particular, oh, that's the way he did it, that's the way he answered. But the style has to be yours, because every personality is different. And today you have the benefit of online hearings, which we never had. You can today watch the finest counsels and judges in action. What actually transpires, learn from it. I remember when we were arguing the Constitution Bench matter, even before the Constitution Bench matter started in the Maharashtra Assembly matters, the first live screening in the country took place, and I was fortunate enough to be arguing on that day before Justice Chandrachud in Court 2, a bench led by Justice Chandrachud. Now, and I thought to myself, I said, my God, can you imagine today how many, and that day about 7 lakh people had logged on to watch those proceedings. Wow. I said, as a student, if I had the benefit of watching proceedings, how much I would have learned. Then came the Constitution Bench, again by a bench led by Justice Chandrachud, where live transcripts started coming. Now, I can tell you, even as a lawyer, it's intimidating, because the moment you say something and you see it on the screen, our system, unfortunately, we get away with a lot here, and the lawyers are to be blamed for it, that we speak beyond the pleadings, we speak beyond the facts, and we speak with great bravado, as if it's something we are very smart we are doing. It's nothing to be proud of. In no jurisdiction in the world are you allowed to speak beyond the facts, contrary to facts. The courts will come down very heavily on you. Get away with it very lightly in this country. Now, the moment you see a live transcript, you see, oh my God, now it's been noted. This is something I'm bound down to. I've said it's now recorded. So all that I'm saying is, with all this happening, today you people have the benefit. You can, in fact, it's not a bad idea on a daily basis. Take out 20 minutes, half an hour, pick up some of the important hearings, watch them. If nothing else, to answer your question, coming back to the beginning of your question, skill sets, how to approach a court, how to address or how not to address a court, is what you learn from these proceedings.
Thank you so much. Just towards the end, and this is on a slightly personal note for you. How would you characterize your experience as a student growing up? For all the students who are watching this and reading
Law
this,
student, school, BA, which part of my college journey are you asking?
in particular, your law school journeys.
I loved it. I loved every bit of it. I was very active in moot courts. So I mooted a lot. I thoroughly enjoyed it. Although, believe you me, we all, after having mooted a lot, we come with the misconception that now we are ready to argue. Nothing prepares you for the court because, a different judge, a different mindset, a different case, a different opponent, it's a different ball game. But nonetheless, it's a step in the right direction. It opens you up. It gives you the confidence to address it. It teaches you how to litigate, how to research. So I enjoyed my mootings. I also was the convener and I did a lot of informal discussion groups. I don't know whether your law school does it or not. We would very often invite public figures, politicians for discussions with an open house, students questioning them. So I had the benefit of interacting with some true giants in this country who came to the law school and interacted with the students like Dr. Karan Singh, Mr. L.K. Advani, and others, Mr. Shahabuddin. They all came and they interacted with the students, and it was an open, the then law minister. And I think it goes a long way. It gives their perspective. Ultimately, it's very important to understand the perspective of the people who ultimately enter parliament and frame a law. You must understand how their minds work. They are actually the elected representatives. So it's good for students to interact with them or other eminent public figures. You could get someone from, say, the RBI governor, or you could get Secretary Ministry of Finance to tell you something about the financial issues dealing with the country and the legislations being made. The executive gets represented there. Get a few judges to talk to you in an open house. Don't get judges and lawyers for boring one-way lectures. We are not the best of public speakers. So we come, we just give this prepared half an hour lecture and walk away after that. Get them into an open discussion with you. Have an exchange of ideas and views with them. These all go a long way in making the legal journey of a student interesting.
Yeah, Mr. Talwar.
Yeah, I mean, for me, so I did a 3+3, unlike you guys. So by the time I joined law school, I think I was a bit more sure of what I wanted to do. Having said that, by then in DU, we were a part of this 4-year undergraduate program, which got shelved after the first year. So in other words, despite being from a college which had attendance requirements, we had none. So that meant that I did way too many parliamentary debates for my own good after the first year. And I think that was something which was a bit different from mooting, but I really enjoyed it. Because mooting actually approached with a sense of research and authority, whereas PDs are a lot of faff. But the only thing I guess it gives you is that you can answer reasonably with some level of articulation on the spot. So that's one thing I really did enjoy, apart from several things I shouldn't say here. And in addition to that, in law school, I think I enjoyed, or I realized that I liked litigation. I would be extremely happy to hear about a new case or a new judgment. And I think if you nerd out about something which you want to call your vocation, that's a good sign that it's something you're actually interested in. And like Mr. Kaul was saying, we used to have some IDGs as well, informal discussion groups, you'd call people. So yeah, I think do a mix and measure of a lot of things, and not to sound preachy at all because I can't, I'm very young. but do other things in the sense that,
Absolutely. Travel,
yeah,
music, books, go out. Don't take yourself and life so seriously that you have no other hobbies. According to me, the finest legal minds in this country, the finest legal minds, and I had the privilege of interacting with some of them, had many varied interests outside of law. Music, literature, travel. Please do that. Don't get stuck to this boring thing of who became a senior, who's getting elevated, who's coming to the Supreme Court, and you don't think beyond that. That's just one facet of your existence. There's so much more to life than law.
Thank you so much. I think we can take a lot away from that, particularly working on our hobbies. And also, you mentioned informal discussion groups is something that you did. That is something that we are endeavoring to do, which is why we have you here today. Like you said, a giant of the profession. And perhaps if your schedule permits, one day we'd like the broader student body to interact with you and someone of your caliber as well. So thank you for that. Just one final question on a concluding note. I understand that your time is valuable. Uday, would you like to, since this was your idea?
Which one?
The very last question.
Yeah. So again, what would you say was your most memorable experience practicing in 2024?
2024 was very interesting on the legal side or my hobbies. Which one are you?
On the legal side.
The legal side. On the legal side, I think one did a few constitution benches, which was undoubtedly the hallmark as far as the 2024. Because to me, if you ask me, nothing gives me greater pleasure than arguing before a constitution bench, and that really elevates the experience of a litigating lawyer. So that was very interesting. Uh, just before the then Chief Justice, Justice Chandrachud, retired, we mentioned a review before him. He was kind enough to take it up. It had raised some important issues, and given his time constraints, despite that, within the 10 days that he had, did he not hear us fully? He gave a decision, he reversed, laid down, reiterated the principles of review, etc., which was very satisfying. That something which we thought a wrong had been done got rectified within the last 10 days, and it was a challenging hearing. Other than that, I think the Constitution bench appearances was really, really the interesting part.
If I may ask, otherwise, even outside the laws.
Books, music. I attended the Coldplay concert very
wow.
recently in Budapest. I'm fond of listening to Dua Lipa. I like that a lot. I like reading. I watched a few movies. Lapata Ladies was a good movie that I watched. I watched 12th Fail, which was again a great movie to watch, and many others.
Thank you so much. So, Mr. Talwar?
I mean, for me, there's not a lot of thought behind it because before this CB hearing, the office I work in doesn't allow us to argue too much because of the nature and stake of the dispute. So the ones I do argue, my cases are my own ones, and those are from 30,000 up till the High Court. So then, when I got a chance to argue this CB, for me that was a clear highlight, and the fact that it went reasonably well meant that there's nothing to rival that experience on the legal
No,
front
I
for
think
me.
he's being very humble. Let me add, he does a damn good job in the Supreme Court. I
Yeah,
watched
I
him
mean,
once, and he does a damn good job in the Supreme Court. Yeah.
no, but to be fair, another thing in 2024, now that Sir has said it, we were doing a case where obviously we briefed Mr. Kaul, and I think he was 2 to 3 minutes late in coming. And the present chief was the one who was hearing the case, and he told me to start. And I was also extremely tempted. So after a couple of, okay, no, please give me time, I started. And then I was on some flow, I was going on, and I looked to my left, and Mr. Kaul is sitting down and prompting me. And for me that was an out of body experience because one, that he was there, he wasn't, obviously he could have taken the dais, and naturally that would have been his right, being the senior counsel there. And secondly, the fact that he wasn't just sitting, but he was telling me which date and which document to look at. So here and there, even that was a fantastic experience, to be honest. And it's, I mean, through people like him that especially first generation lawyers get a lot of impetus. So that would be the second experience now that I think about it. And outside the law, I went to see a football game for the Premier League for between Aston Villa and Sheffield, which wasn't a fantastic game, but the experience was great. So I play football a lot, so that was a fantastic memory. And what else? I recently went to Kerala. That was great. Someone told me to try and cross a river. So I swam one side, but then I realized that utna stamina hai, par वापसी का नहीं hai. So that was a half-baked experience, but that was fun. So yeah, to answer your question.
So I'm going to give you one unasked answer, an unsolicited piece of advice,
No,
which I feel very, very strongly about when you asked about starting out on your career. Please avoid a toxic workplace. If you ever feel there is toxicity, leave the place, because toxicity can lead to your leaving the profession. You have no need to subject yourself and your mental state to a toxic workplace ever. Secondly, there is no bravado in people telling you that till you don't sit till 2 o'clock at night, you will not make a good lawyer. You must have a weekend, you must take your holidays, and it is not necessary that everyone should keep sitting in an office till 12 o'clock. In today's times and age, you can come home, deliver on your work, go back. Of course, diligence, discipline, hard work, goes without saying. But this whole logic that everyone must sit till 1 o'clock, then the boss wakes up at 3 o'clock, tells you to do a draft at 3 o'clock or wants a conference at 5 o'clock is bizarre. This is a profession where you go on till at least the age of 70. And to enjoy the profession, to enjoy the journey, to avoid burnouts, you must have good regular. Of course, working hours will be late. This is a profession where you can't return home at 5. That everyone knows. But there's a difference between returning at 8:30, 9 and returning at 2 o'clock in the morning and getting up at 7 again. There may be all-nighters. We've all done all-nighters once in a while. But it definitely should not be the norm. This is more an advice not for you, but the way we are running the legal profession. And I think we also need to introspect and correct things as far as welcoming the new generation is concerned.
Yeah, in offices sometimes, especially in litigation, I don't know how this culture came about, but people think that the longer you stay, the more productive you are. But I think it's the opposite. There's an inverse correlation between, people saying मैं तो 6 बजे शाम को काम शुरू करता हूँ और मैं 12 बजे तक बैठता हूँ. But the point is, you just maximize the time you have to work in, then you won't have to sit till 1 or 2.
Glorification of hours and glorification of sitting till 1 o'clock at night in the office is just not right, according to me. People may disagree, but that's my view.
Thank you so much for this brilliant advice. This has definitely been, even though the year is just starting, one of the highlights of my year, speaking to the both of you. All of us will definitely take this forward, including us editors, and our audience will also take this forward in the profession. Thank you so much for your valuable time.
Thank you very much for having us in your panel discussion. All the very best to all of you and your institute.
Thank you. Thank you so much.
Thank you so much.
Thank you.
Thanks, Prem. Thank you, Neeraj. Thanks, Uday.
Thank you.